funding of the $1,500 payments has been an issue. The government wasn't particularly sympathetic to that, but they did speak to the banks, and hopefully for those of you who needed assistance or your clients needed assistance, they've got a sympathetic year from their banks. However, now that we're into the payment cycle, perhaps things are a little easier in that regard. Of course, you must remember that the payments are taxable, so you will be, when you're doing your tax return, those will be taxable amounts. For those people who haven't registered, you've got till 31 May, so another 10 days, and you'll be registering for the April and May months. So yeah, that's a date that you need to keep in mind for those who haven't registered. If you are registered, you'll be into doing your monthly statements. So of course you need to remember to submit those. You'll be confirming that your business and your employees are still eligible for the JobKeeper allowance, and you'll be also required to put in your GST turnover and projected GST turnover. The statements are not there to test you to see whether you're still liable. It's an information gathering exercise. We're in the current fortnight that we're in is the 11 May to 24 May cycle. So of course the $1,500 needs to be paid by the 24th of May in order for you to get the reimbursement. If you are looking to register, of course we still have the 30% fall of turnover as compared to last year for those with a turnover of less than $1 billion, and then a 50% test for those in excess of $1 billion turnover. As I'm sure a lot of you know, a bunch of alternative tests was introduced in April, a little earlier this month, last month. There's 7 of them. I'm not going to go through them, but if you're not fitting into the basic test, then it's worth your while having a look at those alternate tests, and they all involve a type of averaging of turnover for a period. So it's worth having a look to see whether the alternate tests are an easier one to pass if you're looking to register at the end of this month, before the end of this month. You've obviously got to remember your eligibility requirements for your employees, whether they're a full-time or part-time fixed-term employee, they're a long-term casual. And actually, in respect of long-term casuals, some of you may have heard of that there was a decision that was brought down actually only yesterday about long-term casuals. And I might just pass to Kate just to give us a little idea as to whether that decision will have a bearing on the status of casuals, and in particular how that might then apply to the JobKeeper allowance. Kate?
Thanks, Mike. That was handy. I'm not sure if there's a problem with the sound.
Yeah, I think that's resolving itself now.
Yeah, so the decision that was taken down yesterday involved work, and it was actually on the back of work pack and scheme that was handed down a number of years ago, probably 2018, and that was really a catalyst for a significant change, especially in the mining service provider sector, because essentially it looked at who was a genuine casual and how are those characteristics of a genuine casual assessed. So there was that first decision of work pack and scheme. Then there was a similar case that was commenced by another employee of Workpack, and that appeal decision was handed down yesterday, confirming essentially who is a genuine casual, and it's very much a person that has that regularity of employment, that commitment to ongoing systematic employment. There's an expectation that they'll be provided work, there's an expectation that they will accept that work, and really it confirms now that it could even be that the assessment period is as short as 6 months. It may not need to be regular and systematic employment for a period of 12 months. That could be considerably shorter, where that employee is very much deemed to be a genuine casual. So in terms of the JobKeeper, it could mean that actually there's a much greater those casual employees to now in fact be eligible for JobKeeper. So I would encourage you, if you do have casuals that perhaps haven't met that 12-month criteria, maybe it, because it could be in fact that on the back of this decision they'll need to rethink how JobKeeper applies to casual employees.
Thanks, Kate.
Mike and Kate, I'm just going to jump in there because I've got a question from Michael Mazzarella. Michael, did you want to ask your question? I'll just take, you can take yourself off mute.
Let's start video.
Oh,
Morning.
there we go. Morning.
I've had to take my morning tea away. Just had a question about JobKeeper fortnights. What are your thoughts about payments within the fortnight or just with respect to the fortnight? We've got some clients that their fortnights don't match what the ATO fortnights are, and they've been paying outside of that fortnight.
Well, from what I've seen, if you say paying on a monthly rather than a quarterly basis, they do permit you to allocate that monthly payment to the fortnights in a reasonable manner. Otherwise, it seems that you are required to pay within that fortnight. That certainly seems to be the rules. So if your fortnight cycle is slightly out, I mean, I'm assuming it's only going to be out for 1 month or one cycle, because you're going to have the payments will be made at some point, and you might fall into a later cycle or an earlier cycle, if you know what I mean. Because if you're paying in a fortnight, well, it's going to fall into one of the official cycles at some point.
Yep. Yeah,
it's a question of allocating the particular one which is actually paid in the fortnights that the ATO have laid down.
Okay.
Does anyone else have any comments in that regard? No, but I certainly, from what I've seen, you actually have to pay it within the fortnight, or if you're paying monthly, you can allocate it on a reasonable basis. That's what I've seen anyway.
I can quickly comment on that because we had a client with a very similar situation, and they'd misinterpreted the rules and were looking at the work done in the fortnight rather than when it was paid in the fortnight. And we applied to the ATO for discretion and do back payments, and they came back and said that was all fine. So I think, yeah, applying for discretion for any back payments should hopefully be okay.
That's great. Thanks for that. I mean, certainly everything I've seen and read, and when I've spoken to the ATO, it's all about trying to facilitate this. They're not trying to apply rules strictly. They do have an open mind to this sort of stuff. So certainly, if you've got an issue, certainly raise it with them, and I think you'll find they are quite reasonable in dealing with the questions that you've got.
Just got a comment from Roy Mellon here as well, just saying it's your pay date. Your pay calendar does not need to relate to the ATO calendar. You just need to make the $1,500 a fortnight based on the payment date.
Okay. Just one other point I wanted to make on JobKeeper is that it's important that if that's sort of one in, all in, you can't pick and choose as to which eligible employees are going to be part of the scheme. So it's again, if there's some specific reason, you may well get the ATO to exercise some sort of discretion, but it's the rule generally is that it's a one in, all in. Some of the other concessions which I wanted to touch on today include the boost of cash flow, which should have been paid. This is the amount between 20 and 100,000, which is paid by way of a credit to your activity statements. Again, these should have already been payable. You've effectively split between two periods, March to June and June to September, and you're capped at 50,000 for each period. What is important is that you lodge your activity statements. You don't lodge the activity statements, you're not going to get the payments. And And it's also useful to know that they're not setting off these amounts against other tax debts. So if you owe amounts from an earlier period, they're not going to set off these payments, which is very generous. It's also important to remember that the cash flow boost is not taxable. So unlike the JobKeeper allowances that were taxable, the cash flow boost is not. You're also entitled to claim your PAYG amounts for that particular period as well, so they remain as a deduction. What you do need to be careful of is that you're not putting in place any fancy schemes or arrangements to facilitate this boost. I think they will come down pretty hard on people who try to put in artificial arrangements to facilitate payments. So just be careful of that. And I think we can expect them to be pretty hard-nosed where these sorts of arrangements are put in place. A couple of the other supports include the instant write-off, and this has been boosted up to 150,000, and it applies to anyone with a turnover of less than 500 million rather than 50 million. So obviously it includes a lot more businesses. You have to have bought the equipment or the depreciable asset between 12 March and 30 June. So obviously we're in that period right now. If people have got some spare cash to pay for these sorts of assets, this is a good time to be doing it. Likewise, there's accelerated depreciation for assets acquired after 12 March, and they must also be used between 12 March and 30 June. So any of the larger assets worth more than $150,000, it's important that you've not only bought them but have got them ready for use in this period. There are some exclusions, and I'm not going to go through them all, but one that caught my eye was that assets that you'd committed to buy before the 12th of March are excluded from this accelerated depreciation. And I'm not quite certain from a legal perspective what that means. Does it mean that you've actually signed up to buy something, or whether you've just requested a quote? It's quite a broad category, that. So I'll be interested to see how that's interpreted. But my suspicion would be that, well, if you've actually signed a contract to buy, it may not have been delivered, then that's going to be a source of some dispute as to whether the acceleration depreciation is still applicable. The rate that you get, there's a differing rates depending on how big you are as an entity. But in broad terms, for the smaller businesses, your increase is from 15 to 57.5% depreciation. So it's a significant difference. And for other businesses, the bigger businesses has gone up from a flat 50% plus basically half of what you would have got under the normal rates. So you can see the accelerated rates are really significant, and of course, if the business is in a position to buy these assets, now's the time to be doing them. You're probably also aware that there are concessions relating to the lodgement deferrals and payment deferrals, and again they seem to be reasonably. The ATO seems to be pretty favourable in granting these concessions. You do though have to apply online, and then once you put in your applications, it's an automatic deferral system. For the accountants out there, they're not going to be applying the 85% performance benchmark stringently for this period, so that's a good thing from your perspective. With debts, with any of the tax debts, whether it be GST or income tax or FBT or any of those, if those are, if your clients or you are struggling with those sorts of debts, the big thing is to contact the ATO, talk to them about it, and work out what can be done. I think you will get a very sympathetic ear from the ATO. Certainly that seems to be the policy, that people are going to be given a break, and they should at least be able to defer some of the payments that are due. So talking of debts, Kelly will now chat to us a little bit about debtors and creditors generally, and how they're going to be dealt with those post-COVID. So, Kelly?
Thanks, Mike. Can you guys hear me, or have you got a bit of feedback from me?
Actually, Kelly, just before you start, I'd forgotten the state taxes, so I might just quickly mention those. There are, as you probably know, payroll tax relief, and this is quite significant. The threshold in WA has been increased to $1 million from 1 July, so they brought that forward. There's a one-off grant of $17,500, which for employers with wages of between 1 and 4 million. There is a potential waiver for payroll for the period March to June for employers who have taxable wages of less than 7.5 million. And just recently, they've announced that they won't be assessing payroll tax on the JobKeeper allowances. So effectively, the first $1,500 of each employee's wage will be excluded. So that's if you're within the JobKeeper allowance scheme. So those are the payroll taxes. And there are also land tax concessions, which relate to a 25% rebate if there's been some minimum, if you satisfied the minimum requirements for granting a commercial rent relief. So those are also worth looking at for this period as well. So sorry, Kelly, so you can now talk generally about creditors and debtors.
Great, thanks, Mark. Okay, can you hear me now? There's no feedback, is there? No, okay. So many of you might be aware that there's been some changes to the Corporations and the Bankruptcy Act as part of the stimulus packages that the government announced. So there's essentially a moratorium on bankruptcy notices and statutory demands, both of which are normally 21-day demands to either pay up, or a company can be wound up, or a person can be made bankrupt. And the limits for issuing both of those sorts of notices have been lifted to $20,000 as well. So, sorry, I should say that the time for dealing with those has been extended out to 6 months, so until 25 September 2020. That means that enforcement of debts is going to be difficult for the next few months. Cash flow is tight for companies at the moment, so negotiation is going to be the key to dealing with your creditors and debtors at the moment. I think early intervention is always the best option. So getting on the front foot and looking at, if you're not going to be able to make any of your payments, contacting the creditors early on, and starting to negotiate payment terms. It's a good idea to make sure that the payment terms are documented as well. So making it clear, what are the dates that payments are due? How much are the instalments that are due? Is there an acceleration clause that if you miss a payment, the whole thing becomes due and payable? Taking the opportunity to get security if you don't already have security for your debts. So negotiating in relation to money that you owed or money that you owe is going to be a key. One of the other legislative changes that came in was that there's a moratorium on insolvent trading. So that's for companies that do ultimately fail. There's no risk of insolvent trading for the period between 25 March 2020 and 25 September 2020. Just very briefly, for those that aren't familiar with it, insolvent trading is essentially where a director has incurred a debt on behalf, well, the company has incurred a debt at a time when the directors knew or should have known that they couldn't, the company couldn't afford to repay that debt, and a liquidator can make the directors personally liable for those debts moving forward. So it's often a big risk with companies that are struggling, and a decision that they have to make. Sorry, I'm admitting people through the waiting room as well as I'm speaking. it's a consideration that directors often have to deal with when they are considering the future of a company and weighing up their personal liability with continuing to trade. So removing insolvent trading as a potential liability it is a good option, and is something that all businesses can take advantage of through till 25 September 2020. I think going back to the negotiations with creditors and debtors and your terms and taking security, for those businesses that in their terms and conditions previously they've got the ability to take security but they don't actually register that, now's a good time to start enforcing that and registering it. Most businesses are going to have some form or some cash flow bumps, even if they don't have cash flow problems, because even though their business might be doing well, their clients' businesses might not be doing well. So taking security and taking security early is a key. You don't want to be in a situation where you've left it to the last minute and your security can be voided. So that's how I'd say that things have changed and will continue to change in the next few months in relation to debtors and creditors, Mike.
When a business owner is looking at their cash flow and forecasts, what do you think are the important considerations? Obviously, your debtors and creditors are a big issue, but what other factors should be taken into account?
Sure. So I think it's important to have a look at some of those stimulus packages that you were talking about earlier, Mike, and really look at the impact that it's having on your cash flow. I think a lot of people initially saw some of the stimulus packages as the saviour of their businesses, but the reality is that it's probably not enough to save a lot of businesses. It will help businesses hobble through this period, but I think if we're to say that come September or even July, things are just going to be roses and we're going to be back to normal would be somewhat naive. I think we're in for a tough rest of the year, if not going into next year. So once those stimulus packages run out, what does your business's pipeline of work look like? I think there's also going to be what I've heard referred to as a debt cliff that comes up towards sort of September, October this year. For a lot of businesses that have taken advantage of the bank repayment holidays or have deferred ATO debts and those sorts of things, or even have deferred rent, the debt's still got to be paid. It's still sitting there. So I think there's got to be a consideration of, with the pipeline of work, what's the ability to pay back some of this legacy debt that has accrued over the last couple of months and will continue to accrue for the next couple of months while we're still in a tight cash flow situation? I think we need to be really realistic about how those legacy debts can be dealt with, and really honest about the pipeline of work as well. There's no, I suppose, silver bullet in this regard. It's just being really conscious of where you are cash flow wise, and asking the questions about your pipeline and the reality of being able to pay back debt.
So if a business is struggling, and was struggling perhaps before the COVID-19 disaster happened, and they're now wondering whether they want to keep on going after we get over this period, what sort of things should they be looking at? If they're thinking, well, maybe this is the end of the road for my business, it's going to be a lot easier to shut it down. What sort of things should they be looking at?
Sure. I think there's a number of questions that I'd be asking initially. First and foremost would be, do you want to keep trading? Do you want to keep going with your business? If you want to keep going, great. Let's have a look at some options there. If you don't, what's your time frame that you want to exit on? Are you happy to keep trading, but you want to do it at a smaller pace? Where, if you scale back the business or if you stop trading, where's your income going to come from? How are you going to meet your living expenses and lifestyle? And what's your ultimate goal? The goal of where you want to be is your starting point. I know that there's a lot of people through COVID-19 have really had a look at their businesses, and it may not be that they were struggling. It may just be that they've lost the reason why they were in business, and just got stuck in the grind. And there are a lot of people just reassessing what their businesses are going to look like moving forward. So I think for those that no longer want to keep trading and that are solvent, that they can pay all of their debts, they need to get some advice on how they can wind down their business, how they terminate employees without claims being made against them, how they collapse their trading structures, how you extract surplus cash and assets in a tax effective manner. And also a consideration of whether things like runoff insurance are going to be required. For those that can't pay all their debts though, it's a slightly different situation. And you're going to need to be looking at some form of an insolvency appointment. Getting in some advice really early on before actually making an insolvency appointment is going to be key to that one, in trying to limit personal liability for directors and owners and attempt to ring fence any assets, personal assets as well. If there's a company that's in the situation of they're just really not sure if they can continue to trade through, but they would like to trade through, then the considerations there are whether there are finance options available, the negotiations with key creditors and other stakeholders that we discussed earlier. If there's options to sell part or all of the business, or sell part of the plant and equipment that are unused, and whether an insolvency appointment, something like a voluntary administration where you do a deal with creditors for cents in the dollar, could assist in getting to an outcome as well. But I think any which way, it's important to get some advice from your accountant and your lawyer really early on about what your options are to maximise what those options could be.
Okay, that's great, Kelly. Are there any other questions out there on the topics that Kelly has raised? If not, Kelly will now start putting a few questions to Kate.
Sorry, I thought I might just jump in there. From an employment law perspective, when companies go into administration and are ultimately wound up, there's unfortunately people think that all employees then are not able to commence proceedings and bring claims against companies that have gone into liquidation and that they're in the process of being wound up because those proceedings are stayed. It's really critical for businesses, especially with a large workforce. Unfortunately, the Fair Work Commission is a little unique. It's not considered to be a superior court whereby those proceedings would be automatically stayed. So it is critical that where you are going through that process of being wound up and you're looking to make staff redundant, that you do engage in a lawful process, because if you do not, I've unfortunately seen it a number of times, those employees are then able to pursue unfair dismissal claims on the basis that it wasn't a genuine redundancy, the genuine redundancy process wasn't followed, and therefore they are deemed to be a protected employee and can pursue claims in the Fair Work Commission, notwithstanding that the company has actually gone into administration and perhaps has been wound up. More often than not, those proceedings would continue and may even continue against the directors in their personal capacity. So please just do be mindful of that. I thought I would just throw that in there, Kelly.
No, thanks for that, Kate. That's really important. I've just got a comment from Steve at Macquarie Bank as well, and he's just saying that they're also seeing some businesses that have found some new ways of doing things which will create some very good ongoing efficiencies, and some will come out better and leaner, which is great. And I really agree with that, Steve. I think there are a lot of opportunities and that a lot of businesses have found some positive ways to continue to do business in a better way and will be more profitable moving forward as well. All right, so I'm going to switch tacks again now, and I'm going to ask Kate some questions. So Kate, from a workplace and employment perspective, can you outline some of the issues that workplaces should start to consider as the government eases the restrictions and employees start returning to work?
Sure. Look, employers are going to be faced, if not already, with quite a delicate balancing act. Essentially, they want to regain productivity as soon as they can. They also need to mitigate this dual safety risk of either a workplace COVID outbreak, but also the ongoing and potential damage to employees' mental health. Now, in reality, there may not be the same number of employees returning to the workplace, perhaps as there were previously, but certainly employers will need to manage that complexity of workforce logistics, and they certainly need to be aware of anti-discrimination legislation and award compliance, whilst also balancing the operational needs of the business, and certainly in a considerably changed market. Now, some of you may be aware, Scott Morrison recently announced 10 national COVID safe workplace principles, and they underpin Safe Work Australia's workplace health and safety guidance. I would really encourage all of you with a workforce to become familiar with those principles. But essentially, some of the common issues and considerations that will need to be planned for, and certainly that we are giving guidance to our clients, they need to consider managing access to the workplace. So, how do those employees gain access to the building? Is it through lifts? Is it through reception? How do you manage visitors, clients coming onto the premises? Will those numbers be counted? And who will be responsible for monitoring that access? Secondly, how will social distancing measures be addressed in the offices, in workspaces, meeting rooms, even walkways, lifts, tea rooms, kitchens, toilets, any area in that workplace? How are you going to manage those social distancing measures? So, you might even want to consider staggering working hours so that all staff are not in the office at the same time. So that will mean, obviously, you might have some still working from home and some being in the office, and you might work it on a rotation basis. You will need to give consideration to the type of cleaning protocols that will be used with staff coming back into the office. It was relatively easy to manage while staff were perhaps working from home, but now with that increased number of bodies in the office, who's going to be doing the cleaning? If plant and equipment is shared, how will it be cleaned, by whom? And what about high touch items like photocopiers? We have heard of some stories where cleaners are coming around on the hour or every second hour, cleaning everybody's keyboards and mouses and photocopiers. That may be a bit extreme in some circumstances, but is certainly worth considering. You may need to consider providing additional PPE personal protective equipment to some of the employees, gloves, masks, antiviral gel. Those things should be readily available. You might also want to give consideration to how do you effectively consult and communicate with employees during this phase, and because this is going to be the most difficult phase of this sort of transitioning of the return of people to work. Are there different start finishing times, the rotating of teams, rotating of others working from home? It is critical. We also encourage businesses to consider whether there's a need for refresher training, perhaps on either work tasks or equipment or dissemination of information. It is critical that that reorientation or reinduction process is managed, because it does limit or mitigates against businesses' exposure if in fact claims are ever made against companies. So I would encourage all businesses to refer to Safe Work Australia's extensive resources. They are free, they're available online. They certainly address some of the issues that I've outlined about how to minimise that risk of exposure to COVID. And I believe there are a number of really useful checklists, which include physical distancing, cleaning, health, hygiene, and all of which will assist businesses to address that immediate need to create a COVID-19 safe workplace.
Right. Yeah, I think I've certainly been talking to clients that, particularly in the larger buildings on the terrace, are talking about certainly splitting their workforce for taking into consideration that it could take an hour for people to get up in the lifts if everyone's back in force, but there's limits on how many people are allowed in the lift, but also to manage the risk that if there was a secondary infection spike, that the whole of their workforce wouldn't be taken out at one point if there was an infection within the building. So I think that's a really good point.
I mean, the mining sites have done that. They've put all their teams on rotation, so your whole entire workforce isn't taken out at the one time. But it is, those points that I raised are critical. So I really would encourage you use the resources that are available. But if you need to,
great. Okay. So, whilst it's important that some of the things that you've outlined may in fact be a significant burden to small businesses, is it all necessary? And what's the risk for businesses that don't implement those risk management practices?
Look, I certainly appreciate that for small businesses, a lot of those measures that I outlined could in fact be quite a burden. But essentially, at the end of the day, employers have what we call a non-delegable duty of care. They have to ensure that their workers are not exposed to risk and that they're provided with a workplace free from hazards. And the definition of hazards extends to COVID-19 infection and disease. So employers have to do everything reasonably practicable to ensure the safety of their employees. And that includes ensuring that all risk management practices have been implemented to ensure that those employees are not exposed. Now, what a small business might do is very different from what a large corporate entity might do. So it is what is reasonably practicable for your business. There was a recent decision that was handed down earlier on this month by the Supreme Court of Appeal. It was a matter called Allied Pumps and Hooker. And on the back of that decision, I cannot stress that employers will really need to be even more vigilant and carefully consider whether there is a foreseeable risk of COVID-19 related disease for employees returning to the workplace. And if so, then what is a reasonable response? Now, that case is not a COVID-19 related case. It essentially was a damages claim arising out of a workplace injury. So the plaintiff, Mr. Hooker, he suffered spinal injuries as a result of his reaction to being startled by a loud noise. I think there was an alarm, there was perhaps an employee who was working on that alarm, and it was activated in close proximity to him at his place of work. So he turned suddenly, twisted his neck, injured his cervical spine, and then he, I think that resulted in a secondary injury to his back, and then later psychological problems. Yes, none of that is particularly relevant other than to say that certainly in the joint judgment on appeal, the court was very, very strict about the employer's duty of care and in fact how far and wide that duty extends. Now, we've already seen quite a spike in workers' comp claims relating to COVID-19. I'm certainly aware of at least 175 workers' comp claims already that relate some way to COVID-19. And whilst that number might not seem significant, I can assure you it is in relation to workers' comp claims. So it's critical that businesses do everything reasonably practicable to ensure that they're minimising that risk and exposure to claims, be it comp claims or even workers' comp claims. So yeah, I cannot stress that enough.
Okay. All right. So, but when we're talking about employee health, we're not just talking specifically about COVID-related disease, are we?
No. So a reference to employees' health includes their mental health, and a COVID-related disease is just limited to being infected with the COVID virus. So there's probably two, and certainly it's not limited to just these two, but there are two health issues that have become prominent over the last few months during the pandemic. And one of them is essential worker burnout during the COVID-19 crisis. So what some of us actually may have encountered, especially in the IT space, especially in the accounting industry, is a greater demand on essential service workers. And so to meet that increase in demand for service, those employers have been requiring their workers to work considerably longer hours, perform additional duties, and often under pressure and significant time constraints. And so the concern is that as the crisis continues, that this demand is going to possibly even continue to intensify, and that's at the risk of widespread worker fatigue and burnout. So it is critical that businesses are reviewing those work schedules, especially for those in-demand employees. They ensure that workers who are working those additional hours have an adequate amount of rest time in between those shifts. Perhaps you might need to look at training your managers and supervisors to monitor recognising signs of fatigue and being able to assess those employees' fitness for work. And also train those employees to recognise their own signs of fatigue. You might even need to consider their commute to work. You know, a lengthy commute will extend a worker's day. So, you know, perhaps how can a business help in managing that commuter's work so that they're not even more fatigued? The other thing that we are seeing a huge spike, and a lot of those workers' comp claims were actually specific to psychological injuries and stress. So psychological risks could include anxiety about the ongoing health crisis, the fear of infection, especially again if they're required to commute to work, social isolation due to the lockdown. Now many will have experienced perhaps some challenging domestic situations. They may have been juggling childcare, caring for a vulnerable relative, and then, you know, the obvious, the financial worries, perhaps if their partner or spouse had been made redundant or there was a loss of income. And some may have experienced themselves illness or bereavement. So it's critical that businesses are aware of their employees' personal circumstances and situations. Now, especially where you have staff perhaps who have carried on work and they've been participating remotely in video meetings, they may not have that same degree of isolation, but there will be an adjustment as they transition back into the workplace. How are they now, having had perhaps anywhere up to 10 weeks where they've been at home on their own, perhaps just for the company of their dogs, how are they now going to manage adjusting being into a shared work environment with colleagues? And you may find that, you know, some employees are not, they might be prone to sort of aggressive outbursts, not because they're normally aggressive, but just because they're back in that environment where they're having to share resources and be a little bit more considerate of others. So look, those psychological risks are real, and for those businesses that don't have an EAP service provider, I would strongly encourage you to get one, and really make staff aware that those services are available.
Okay. All right, so what about the businesses that are thinking that they're probably overstaffed now in this new environment? Should they still be considering redundancy as a viable option?
Look, some of you who have had the benefit of speaking either before or directly to, redundancy is a bit of a vexed question, because whilst you might identify that the position is no longer required, you may not have that immediate cash flow to be able to satisfy paying out all of the employee entitlements. So employers that come to me and say, oh, we just need to make a huge amount of our staff redundant, I really have to question them and see that, is that a good financial move? Because whilst I appreciate that it may immediately solve a problem where you don't have to continue paying the wages, there may be significant leave accruals, and if they've been long-term employees, you may have huge amounts of redundancy pay to make. So interestingly, there have been 2 cases that have come before the Fair Work Commission specific to reducing redundancy payments. Surprisingly, it has only been 2, and there's been contrasting decisions made in respect of those particular cases. So one was an architectural joinery firm, and the Fair Work Commission in that particular case did approve the employer's application to reduce redundancy entitlements. I think the employee was entitled to 7 weeks, and they in that situation reduced it to 1 week. They took into account the significant financial strain that the employer would suffer if they were forced to make payment of 7 weeks redundancy pay, as well as all the other leave entitlements. So there was extensive evidence given to the Commission in that case about the amount of notice that was required, the leave entitlements, redundancy pay measured against the cash flow of the business. But on the other hand, though, Worthington Industries, the Commission rejected their application to reduce redundancy pay for 3 workers. They were all entitled to 4 weeks' pay, and the application was made to reduce that to 1 week. And essentially, the company just hadn't demonstrated that they had suffered sufficient or significant financial strain. So, look, redundancy is certainly still a viable option for businesses, but you do need to consider whether you have cash flow available. And by reference to the Commission's recent decisions, you may have success, but you also may not, and you've also incurred the costs potentially of engaging someone like us to make that case for you, and it may not be successful.
Yeah. Okay, well, thanks, Kate and Mike. I'm going to throw the floor open for questions. No need to pop them in the chat box. If you want to just unmute yourself and ask your question if you have them. We have a little bit of time before we have to wrap up.
Kelly, Norman Neal here, HLB manager. Just an interesting question that we've been sort of faced with around, I guess, reopening the office. So currently, with the office is closed, we've got close to 75 people working remotely at the moment. We're just starting a staged transition back to the office, and one of the questions I've got is that do we foresee a point where we say the office is open and you're expected to be at the office unless you've got a viable alternative or excuse or need to be?
Yeah, Kate, I'll throw that to you. My understanding is we're going to go on government regulations, basically.
Yeah, so whilst complying with government regulations, you do have to be careful that if an employee has made a reasonable request to continue to work from home, that needs to be considered and can't be unreasonably refused. But looking at it from the other perspective, and if an unreasonable request is made, then it's certainly reasonable for that employer to deny that request, and where the employer fails to comply with that lawful and reasonable direction to return to work, especially where you can evidence that all of those government regulations are complied with, you could then proceed to performance manage that employee and ultimately terminate them. Please do, I must caution though, please do be mindful, where an employee's got care responsibilities or perhaps they may be deemed to be in a vulnerable class, you will need to give additional consideration to that and mindful again of any anti-discrimination legislation.
Yeah, I think the risk around that is more around some of those items you touched on before, where people are experiencing that perhaps anxiety or fear of being back in the workforce and things like that. So I can sort of see that being a tricky one for people to manage.
It is, and look, managing mental health, it is difficult because unlike with a broken leg where you can identify, well, there was the slab that I tripped over that caused the broken leg. Mental health is a vexed area, and also they can already have a predisposition to depression and anxiety. It doesn't just need to have arisen because of the workplace environment and COVID. Kelly, I've got a question that's come through from Steve. He's asked, what about ongoing performance improvement plans that may have been in place prior to COVID? And what's your advice on continuing with this type of performance management? Look, COVID doesn't sort of stay any type of performance improvement plan or performance management process. We are in the courts that courts are more willing to take some. For example, there was an injunction case that came before the courts the other day, and they considered it in the context of COVID. So you do need to consider how COVID-19 and that landscape may have impacted on the employee's performance, and at all, did it contribute to their poor performance? But otherwise, if you had a performance management planning process prior to COVID that wasn't COVID related, and now with the employee coming back to work, perhaps you want to recommence that process that is that's entirely lawful, and in fact should be done, because ultimately if you don't continue with that performance management plan, the employee perhaps falls back into, I don't know what the issues were, but if the employee perhaps falls back into old habits and continues to, you know, there are continuing issues of poor performance, you're going to have difficulty relying on your performance improvement plan pre-COVID if you haven't then recommenced it and then ultimately dismissed the employee. So you're probably a little bit more exposed to an unfair dismissal claim if you didn't continue that performance management plan. Hopefully that answers your question, Steve.
Yeah, it does, Kate. And I guess it was exactly what you've just mentioned there. But also, you know, like the moratorium on bankruptcies and that sort of thing, we take a fairly cautious approach when, you know, in these types of environments with our people as well. And so just making sure that we're not opening ourselves up for any claim down the track if we've sort of continued through a process in, you know, a tough economic and, you know, health sort of time as well. So
I think if you can demonstrate to the Commission that you were mindful of those factors, and whether in fact those factors contributed to the employee's poor performance, and you can demonstrate that you took those into consideration, but there's certainly nothing there to stop you from continuing with the lawful process, but as long as you're ensuring that procedural fairness was afforded to the employee.
Great, thanks.
Okay. I think if no one else has got any questions, we'll wrap up then. And I think the issue Steve was raising raises a good point of, you know, I attended a webinar a couple of weeks ago where one of the attendees commented that the one thing we can guarantee that will survive COVID-19 is our reputations in business. So we have this challenge over the next few months to really navigate the survival of our businesses, what's right by the law, what's right by our values, and how we then come out, how our employees look at us as a business, how our customers look at us as a business post COVID-19. Have we successfully navigated that and been nice people, or have we been the assholes through this process that no one wants to deal with any longer? It's all good and well to survive financially and then find out that none of your clients want to deal with you any longer because of some of the practices that you implemented. But Kate and Mike, if you don't have anything more, or did either of you have anything more to add?
No, thanks.
No, not from me.
Okay. Well, thank you for joining us, everybody. I think we have been signed up to do this on almost a monthly basis. So watch this space for the next one. We'll continue to do Q&A style webinars. So if you have any ideas on topics that you'd like to hear from us on, feel free to drop us an email, and we're more than happy to look into any suggestions there. So thank you again. And right on time, we're going to wrap up. Thanks, everybody.
Thanks, everyone.
Thanks, guys. Thank you. Bye.
Thanks, everyone. Thanks, Kelly. Thanks, Mike. Thanks, Kate.
Thanks.
Thank you.
Thank you, everybody.